Mr. Hart.
I'll start by summarising very shortly our points on the question of statutory construction, which I raised just before the short adjournment, and sort of gather the points together, really. The first is this. There was no radical change in 1991. The enforcement regime was already in place in 1989 when the provisos were in their original form. The second is obviously section 18 sub 8. The third is this. There is no linkage between the provisos and section 94 or indeed section 18.
Sorry, there's no linkage between?
The provisos, no statutory,
yep,
or indeed either explicit or we would say implicit linkage between them. The next point is this. There is a difference in legal analysis between a breach of section 94 duty and the lack of statutory authority which the provisos provide for. The lack of statutory authority, we say, is a pointer towards common law remedies being preserved. We say it does indeed look like a provision designed to stop, a provision designed for civil remedies in order to meet the Allen and Gulf Law defence. That's another pointer towards the common law. The next point is this. The court will recall that whilst there is statutory compensation, don't take the court to it because I took it in Schedule 12, paragraph 4, just to give the reference, 1.1's tab 12, 290. There is compensation for an exercise of the powers by the undertaker. But where the undertaker is acting outside its powers, there is no statutory compensation. Why, do we say? Because common law remedies were intended to be preserved in the 1991 Act. That makes no sense at all, we say, if the undertaker is acting within its powers, discharging clean water which causes damage, there is a claim for compensation. If the undertaker is acting outside its powers, not because it's not exercising its powers, is acting outside its powers, then there is no statutory claim for compensation. Why, we say? Because common law remedies have been preserved by the particular enactment. We simply remind the court of the cases which I took the court to, which Mr. Harris took the court to, simply a list. Pride of Derby, Radstock, Lord Justice Keane in the British Waterways case, which was pre-Marchich but post-consolidation, with remarks about the statutory provisos, and the discussion of trespass in the Supreme Court in the previous, in the Canal case. So we say if one adds that together, there is a strong legislative intent to preserve common law remedies. If so, we do not, we say, fall into the Marchich hole, if I can put it that way. Okay, can I move now to the question of remedy? And the declaration as granted is to exclude all claims of whatever nature, apart from negligence and deliberate. And the question which we raise is this: is it necessarily inconsistent with the reasoning in reasoning in Marchich for all remedies of whatever variety to be ousted? We say it isn't. It will depend on the facts of the particular case, whether that the claim in question is or is not inconsistent with the statutory scheme, because it may involve a claim to build new sewers. And as I say, we say it all depends upon the facts of the case, and we say the judge was wrong to conclude that there should be a declaration in the full terms that he gave. There is a little bit of help on the case-specific nature of the question in the Dobson case, Dobson 1, which Mr. Karras took you to. It's 2.3 at tab 54. Just reminding ourselves what it was about. It was the litigation about odour and mosquitoes involving the Mogden sewage works. The claim, in fact, advanced was in nuisance involving negligence because of the Allen and Gulfoyle rule. But the judge considered the question of whether the various claims in the case were or were not consistent or inconsistent with the statutory scheme. And if I may take the court, please, to page 757 of our bundle. Actually, probably just set the scene a little bit. 756. The question posed at 135, whether what remedies are therefore available in respect to the act or omission otherwise than under section 18. And then there follows passages from Marchich. We note at 138, Lord Nichols didn't rule out remedies in nuisance on the basis of 18.8. Lord Hoffman dealt with that way. And the particular passage I wanted to look at was at 139 over the page. So, quoting Lord Hoffman at paragraph 54. And then Mr. Justice Ramsey said this: those comments and the existence of 18.8 would indicate that there is not a complete removal of all of other remedies, but that what is to be considered is whether, on consideration of the facts, a particular common law remedy can exist alongside the statutory regime of the Water Industry Act. So it's case by case. And picking up his summary, these at 148, page 759. paragraph 148, whilst the principle in Marchich precludes the claimants from bringing claims which require the court to embark upon a process which is inconsistent and conflicts with the statutory process under the Water Industry Act, it does not preclude the claimants from bringing a claim in nuisance involving allegations of negligence, where as a matter of fact and degree, the exercise of adjudicate on that course of action is not inconsistent and does not involve conflicts with the statutory process under the WIA. And I'm simply observing this. In a sense, it doesn't matter whether or not the claim involved negligence or not in terms of the exercise that Mr. Justice Ramsey was carrying out. Because the question was whether it conflicted with the statutory process. And it may be helpful, putting that aside, but to go to the Mr. Justice Ramsey at the trial of the matter, because what he was dealing with in Dobson 1 was various preliminary issues. And for that, one will need bundle 2.4. And within that, to tab 4, sorry, to tab 59. And so, starting at 964, to say this was the full judgment, and if the court turns over to 965, you will see that the court has been spared the first 693 paragraphs of the judgment.
What a shame.
Thank you, Mr. Hart.
And the passage I wanted to take you to was again setting the context, please, at 984, and at 763 there are various allegations as to, in respect of which negligence was being sought, and some of these very considerable, simply covering great parts of the work, of the works, very large works of that. And at 763, that is, and at 764, the judge says this: before turning to those particular items, there are issues of principle I have to consider. First is the availability of funding, and then there is the question of the powers of enforcement vested in Ofwat under the WIA. And so what he then considers that first question from 765 to 768, but it's the second question I wanted to pick up, 769, where Mr. Justice Ramsey said this: in relation to enforcement, I accept that in Marchich, Lord Nichols in particular put forward the enforcement regime as an important aspect in distinguishing between matters which could be dealt with on the courts and matters which were within the statutory scheme administered by Ofwat. In my judgment, that was not intending to say that every claim which could in principle be brought within the statutory enforcement scheme had to be brought within that scheme and could not be brought in the courts. Rather, I consider that he was emphasising the enforcement element of the statutory scheme as being an additional reasons why the court should not be involved in the determination of investment decisions for major works or major projects, which are a matter for Ofwat. And the court will recall the passage which Mr. Carris took you to yesterday about policy and operational being one aspect of the way of seeking to answer that question. And so what the judge then does, and I simply indicate, he then goes through the particular things that were being alleged, and says some of them were justiciable, some of them were not, but he didn't find any negligence. This is 781 in respect of the matters which he'd held to be non-justiciable. The point is that's a simple one, namely this is case by case, claim by claim. What then?
And the test he's applying is the one at where does he say what the test is? Is it 769?
In effect, and he also talks, and this is the context of funding. If you look above that at 767,
whether it's major plants
that's it.
Or minor plants.
That's it. And you have to look in the particular case and say, well, is that going to impact upon? Is that really going to impact upon? Off what, or is it all about capital maintenance? That's the sort of question he was seeking to answer in that case. So we say.
And sorry, he at 767 he concludes that capital maintenance isn't within the statutory scheme. So
Yes, that's it. Yes.
Dichotomy.
Yeah. At the end of 767 follows the decisions of this court where there's been an minor capital plants or minor capital projects would generally come within capital maintenance and would be justiciable because it wouldn't conflict. So.
In the present case, if we take a combined storm overflow, that is going to be put in use when there's heavy rainfall, sometimes when there's light rainfall, depending on how much of the catchment area is being paved over. But I thought the evidence was the only way to deal with that was to build a new bit of infrastructure.
That's the matter I was coming to in this sense, that if our claim, we've had debates about that, but if our claim was for an injunction, then I would readily accept that.
I see.
Our claim is not, it's for damages.
And so, I mean, you're going to come to it, but your case is because you're only asking for damages, you're not really within the non-justiciable.
That's right. Yes, and it will depend. And it will depend on the facts.
Yes.
And it will depend upon the issues about negotiating damages in lieu of an injunction, which is why we burden the court with
one step.
And paragraph 95 of that, really in response to Lord Justice Arnold's point made yesterday that the court hadn't been provided with that. But I simply make this point: it does not inevitably follow from the fact there is a claim in damages in lieu that involves necessarily assessing the cost of providing sewers. There will be a whole host of components in that question, namely, what would the parties be negotiating about, one of which would be relevant and may impact upon it, is what loss the canal had suffered. Now, of course, we haven't got there because because this was taken as a point of law, so that, but it will depend upon, a significant factor in any hypothetical negotiation would be to say, well, what has this foul water done to the canal? And the canal may be able to show, for instance, increased sedimentation as a result of the foul water, which may give rise to a claim for, say, extra dredging or something of that sort. But it's just I'm simply using it as an example to show that the negotiating process isn't just driven by, oh well, United Utilities would have to spend 15 million doing this, and therefore that's the ransom starting point. It's a much more.
But do you accept the submission made by Mr. Karras that the cost of building new infrastructure would be an escapable element of the assessment?
Yes, I accept that. It would inescapable in this sense that it wouldn't. It would be, yes. It would be a component within it. Equally, one can imagine other circumstances where the canal just said, well, I want my money for the sedimentation. So one sees just how claim specific this sort of question is, and that's why we say it was wrong to grant the declaration that was sought.
In those circumstances, then, you're saying that it all turns on how greedy or otherwise the claimant is, in the sense of whether they start at a very high level and say, you'd have to build a new sewer, isn't that funny, it costs X, or whether they say, there's a reduction in oxygenation of the water and a bit of silt. It can't be right, can it, that it depends on how greedy your claimant is?
Well, I don't answer it this way, that what is sought is a declaration that any claim involving the foul water discharges is ousted. It may be that if the matter were to get to trial, the court would then have a look at what exactly it was that the canal was claiming and how it was formulating it, and then decide whether or not, in fact, it would impact upon the statutory scheme. Just as Justice Ramsey did in slightly different context, but in the Oda case of Dobson. So that's why we say that it doesn't necessarily follow that any claim, or indeed would necessarily or probably clash with the statutory scheme.
Why did Mr. Marchich not recover the £16,000 he spent protecting his garden?
It's a good question, Lord. It was again. It's a non. Remember, it's a non-proviso case, and the essence of his claim, again as we debated, the essence of his claim was the claim for a mandatory order in respect of the. In respect.
Yes, but the House of Lords could have said, well, you can't have a mandatory order, but we'll give you damages for the loss the out-of-pocket expense which you've suffered. And that's an even clearer case where the quantum of his financial claim had nothing to do with the cost of building new sewers, but was simply, I've had to spend this money. That's even more divorced from the cost of building sewers than any claim the canal might make.
True, but I'm repeating the point that it depends upon the particular nature of the claim being advanced.
Yes.
Lords, those are my submissions in response. I would invite Mr. Morgan at a convenient moment, subject to anything further you'd like to explore with me, then to address you on licences.
Thank you, Mr.
My lady,
just a moment.
Can I just ask you one question about this, which may be irrelevant, a question about involuntary trespass? What's your submission as to, Mr. Karras accepts that if I take a bucket of water and throw it on my neighbour's land, that's a trespass. And if I build a pipe to discharge onto his land, that's a trespass. But he says it's different here because they inherited a set of infrastructure and they can't, by statute, discontinue it. And that's not a voluntary trespass. What's your submission on that?
I touched on it in opening.
Yes.
It simply, in circumstances where it is a full system, it is unrealistic to accept that it is a truly involuntary process. And I took the court, I think, to Lord Sumption.
Yes.
I think I took the court to British Waterways Board, where there was a discussion of trespass. If I didn't, perhaps I can just invite the court to look at one passage in British Waterways Board case, for which one would need to look at bundle 2.3 at tab 50.
Yep.
And the court goes, please, to 606. Paragraph 36, just setting the context. It's common ground between the parties of the hearing before this court that STW needed the implied statutory authority because discharge of water onto another's land would be an interference with private rights, even though the discharge caused no damage. And then discussion of Allen, but then picking it up at paragraph 37,
yep.
Mr. Beloff at the hearing did not challenge BWB's submission that discharge of water into the canal without BWB's consent would be a trespass unless statutory authority for that discharge could be implied. In hearing, we asked counsel to investigate the point further. The result of their further research is it remains common ground, subject to one qualification, that discharging water onto another's ground constituted a trespass. That's because such a discharge is a direct entry onto land, and the cause of action in trespass does not require damage. And then one can see that the matter was considered simply looking at what Lord Justice Peter Gibson said at paragraph 38. Mr. Beloff suggested a qualification in the case of a direct discharge into flowing water. In such a case, he submitted there would be no trespass. And then one can see what the debate was. So it didn't, one can see from that, it didn't simply proceed on the nod.
Yes, thank you.
can assist the court any further.
No, thank you. Thank you very much indeed.
In which case, I'll invite Mr.
Milady, may I just pick up one point following from Dobson number 2, because it's a separate point to anything that Mr. Morgan will have to deal with. It's this. My learned friend Mr. Hart referred the court to Dobson number 2 for the proposition that each case must be dealt with on a case-by-case basis, and made the suggestion that the declarations that we were seeking here were effectively wide ones. In fact, the relief we sought was by reference to the witness statements and the facts as set, and the facts which have happened in the old regulation. The facts which have happened is that we were facing a pleaded case, albeit in draft, which is set out in paragraph 38 of the judgment of the learned judge below. We adduced evidence by reference to the consequences of that pleaded case, and I won't go over that again. It had the consequences, we say, for our infrastructure, which were not challenged. Against that background, the learned judge at first instance considered he had sufficient to deal with the case which we were bringing in relation to the case which we were facing. This is not a blanket declaration. It is relief in relation to a case which we were facing. It is akin to a strikeout, and indeed the Manchester Ship Canal Company accepted at an early stage, and it's set out in Mr. Justice Fancourt's evidence, that it was considered to be appropriate that the declaration did proceed, and we didn't need to look at everything on a case-by-case basis. So the point on relief, following from Dobson number 2, we say there is nothing in it. This is a case on which all the evidence was indeed before the court, because it was not challenged. They had many months. I think they had 6 months in total in which to put their own evidence in. They decided on the very last day not to put any in. So that's where we are. I shouldn't need to make the point, but if a case of operational negligence is brought, that is not excluded. So those case-by-case, those sorts of cases, of course, do remain. That picks up the point that my learned friend was making, arising out of Dobson number 2.
Thank you. Mr. Morgan.
I find myself once again a tail ender, a real tail ender this time. In relation to the 5 licenses or 6 agreements, 6 candidate agreements, we say that it is important not to lose sight of the context. We are not looking at agreements made between, as it were, amateurs or in ad hoc, one-off situations. We're not looking at an agreement between a local authority discharger of sewage and a private landowner. We're looking at agreements between 2 public bodies who are engaged full-time, long-term in their activities. The local authorities, as those entrusted with the management of the sewage system, and the canal as the operators of a canal under the Statute of Parliament, the Manchester Ship Canal Act 1885 and subsequent legislation, with the statutory status of dock undertakers. So there are 2 bodies, both governed by statute, both with powers and duties exercisable in the public interest, and both entrusted with the proper care and management of their systems. And
When you say the canal company was a public body, was it did it have private shareholders, or was it owned by the public?
I think in its original, I will quickly be able to establish it. I think in its original form, I think it was probably jointly owned by local authorities.
Originally, it was the position was this: it was promoted by as an act of Parliament. From 1892 onwards, it was effectively controlled by the Manchester Corporation until 1987. I think it was 1986, when it was privatised and Peel, I'm not sure which entity of Peel now owns the shares of the Manchester Ship Canal Company. It was privatised in 1986.
Thank you.
Which is when it became the Manchester Ship Canal Company Ltd. So that's the context, and in effect part of that context is the protective provisions available to the canal company when the agreements were entered into. That's the manner in which we deploy those. We don't invite the court to make any detailed findings about the process that led to these agreements. We simply invoke the general context in which they were made. No one can say the exact circumstances in which they came into being. But what we can say is that it was the two bodies going about their everyday business. And there's no reason
Mr. Morgan, I asked you about this submission when you made it first time around, and I'm still puzzled. I could understand a submission to the effect that the court should not lightly conclude that a public authority has acted ultra vires. But does it go any further than that?
My lord, perhaps not, but it's nevertheless a sound and solid point that the court should not be anxious to be persuaded that an agreement of this nature, which recommended itself to several different local authorities. We've seen that it's not just one local authority who entered into this sort of arrangement, it's several that had districts along the banks of the canal. That's the way I would put it. That they each regarded themselves as acting in a responsible manner, and a manner that is beneficial. Whereas Mr. Carris's submissions in effect suggest that there was some serious heterodoxy at work here. And I'm entitled to make the comment, I submit, that if so, it was astonishingly widespread. Now, we accept that, of course, local authorities can exceed their powers, otherwise all the law relating to viaries would not exist, and we do have to address that point, and we have done and will. To descend from that high level of abstraction to a point of detail, I think it is necessary for me to explain to the court a little bit more the position about Outfall 36, because Mr. Carris took you to the agreement at page 514 in the core bundle. And I fear that without further explanation, the court may be puzzled on a closer examination of it. So I haven't got a tab.
Tab 25, I think.
Thank you, yes. It's in the core bundle. It's core bundle 2. Now, the essential position is, as I explained, that somebody went along the bank of the canal and spotted outfalls and then tried to match them to agreements, and there are, as it were, topographical challenges, hence a number of candidate agreements which exceeds the number of outfalls. And in relation to Outfall 36, it is not accepted that this agreement is the one which governs it, and it is not one of the agreements upon which Mr. Justice Fancourt actually adjudicated.
It hasn't come to an end yet, is that right?
I beg your lordship, pardon?
It hasn't come to an end yet.
No. And it's interesting to note that, of course, it is in a significantly different form. It's for a long term during which it is determinable only upon breach. Now, the reason that I mention it, to avoid any confusion, is that on examination, nor does it relate only to intermittent discharges. It includes a discharge from what is defined in the agreement as the sewage disposal works. So it is in itself interesting to note that when we have an agreement that does involve a continuous discharge, one finds it in different terms, which, as it were, gives the discharge more security of tenure, if I may term it that way.
But if it was not one dealt with by Mr. Justice Fancourt, it's not comprised in the appeal.
No.
So why is it before us?
Because it was before Mr. Justice Fancourt, and it was, and I mention it because Mr. Harris put it before you.
My Lord, it is fairly and squarely pleaded within this case that it can be brought to an end by the Manchester Ship Canal Company. We'll go back to the pleadings if necessary, but it is, the principle is in play in relation to this agreement. Now, we can go back in due course. Probably nothing turns on this, but if you go to judgment, page 199 of tab 12 of volume 1, paragraph 96, 3, it was considered as one of the relevant licenses by Mr. Justice Fancourt. That's why I think this court is being troubled by it.
I agree with my learned friend that ultimately nothing may turn on this, but as I said, I'm simply seeking to avoid confusion after the event, where the court says, well, what's this all about?
I'm sorry, so you say, nevertheless, he didn't adjudicate on it?
Paragraph 97 of his judgment, he says that you purported to terminate each of these.
Yes, and that in fact is erroneous in respect of that agreement. So it's almost, as it were, a hanger-on. Because it may yet be found at a trial to be the agreement that covers the outfall. Yeah.
It seems a bit odd that when the draft judgment was circulated, no one pointed out to the judge that paragraph 97 was wrong in this respect.
Yeah, yes, my lord, I agree. It is unfortunate. And as I say, I'm simply seeking belatedly to clarify the point. To avoid
right, your position is it doesn't apply to outfall 36.
We say it doesn't.
And in any event, it hasn't been terminated.
Yes, and I also deploy its terms forensically, as it were, to show that when you do have a discharge from...
Yes, it forms a contrast with the other ones.
Yes, that is it.
Thank you.
Now, but Mr. Carris's arguments would say that that agreement is equally impeached, if I may use that term, even though it could go on for 99 years, and even though the only way it won't is by the breach of the discharger entitled to the benefit of it. And we say that that is just one of several ways to demonstrate that his arguments prove too much. And effectively, we are met with the argument that any precarious right of this nature actually takes effect as a potentially permanent encumbrance on the land, which can only be released at the voluntary behest of the discharge. And we say that is a surprising conclusion. Mr. Karras arrives at this by relying on events which are not bound to happen, unlikely ever to happen, and which, if they happen, may be of little or no consequence.
I think that was your submission before, wasn't it?
Yes, and I'm not going to develop it further. So far as the power to enter into agreements are concerned, to which I took the court, we say that they're all to be widely construed. We accept that the contents of the agreements are limited by general legal principles of vires, but they simply don't arise here. They all provided the local authority discharges with extra rights. They all contain notice periods which are not derisory, and within which it is certainly possible for alternative methods to be achieved, including the promotion and making of a compulsory purchase order. And if the agreements had a precarious edge to them, then it in effect behoved the local authorities to act prudently, to ensure the burden was on them to ensure that they continued to discharge their duties under section 116 or its predecessors. Those duties were upon them, not upon the Manchester Ship Canal. Now, if in that endeavour, if the local authorities found themselves in breach of contract, or if they fail to make alternative arrangements within a notice period, then they find themselves at the end of the notice period in breach of contract and trespassing by the continuing discharges. That, as it were, is again, we say, in effect, their problem, not that of the Manchester Ship Canal. Now, it might reflect on the Manchester Ship Canal by any injunctive remedy being simply refused on the basis that that would cut across the local authorities' duties under the forerunners of section 116. So the local authority would undoubtedly in that respect be bailed out, as it were, by the court, but would remain liable in damages. There is nothing wrong with this outcome. It does not offend against the structure of the Public Health Acts. Now, we must address the question of the extent of the power to enter into agreements under the under section 18 of the Public Health Act 1875, which appears to limit the power to discontinue to circumstances of necessity. But again, that could be addressed by the same solution in the relief and remedies granted that I've just outlined. It is not something which leads inexorably to the conclusion that it is beyond the vires of the local authority to have entered into the agreement in the first place, or that provision in that agreement. And indeed we say also that Mr. Karras's disinclination to choose between voidness of an agreement as a whole and voidness of a single provision within it is just really another illustration of the broad sweep of his arguments in an attempt to prove too much. And if local authorities can enter into contracts, and by and large they can, then the law must countenance them basically being held liable for their breaches. And if that liability is in damages, then no offence to their public law duties under the Public Health Act is done. We don't have the same specific problem with the agreements entered into under the auspices of the Public Health Act 1936, and that governs 4 of the 6 agreements, if such as it is, before the court. So what we say is that in effect, Mr. Karras, in colloquial language, is inviting the court to conclude that the local authorities, or now his clients, can pick out the plums of these agreements and leave the duff behind. And in fact, it's more than that. It's turning the plums into an absolute permanent harvest. He referred you to the school's management case, which is in authorities bundle 2.5, page 65. Page 1175, and the court was taken to...
I'm sorry, Mr. Morgan, could you give me that again? It's 2.5.
Yes, 2.5, tab 65, beginning at page 1175.
Thank you.
And the court was taken to paragraph 150 in the judgment as to the effect, at page 1220, as to the effect of a public body lacking statutory powers. And I shan't read the following passage in extenso, but I do invite the court to have regard to paragraph 154. In public law proceedings, it is clear that the court may refuse to grant relief declaring a contract to be invalid as a matter of discretion. And equally, of course, the court has a matter of discretion not to do so. And it goes on, under one consideration, which may well weigh strongly in a decision to do so, is whether the contract was entered into with a person acting in good faith who would be prejudiced by the declaration of invalidity, particularly where there has been delay in bringing a challenge. Now, we say we are here in the realm of public law, and the situation is more nuanced than suggested by a reading of paragraph 150 taken alone. My learned friend then next pressed upon the court the what he termed the Neuberger analysis in the decision in the same proceedings as these in 2014 in the Supreme Court. What I would say about that is that it only arises if any form of implied statutory power is to be carried forward in the first place, and what we're saying, for reasons urged on the court on Tuesday, they do not apply here. The further point which I seek to make, and I mentioned this but didn't develop it, is that Lord Neuberger's analysis was expressly stated to be in the alternative to the one which forms the actual ratio decidendi of the decision. And in effect, it would appear that the court is saying, well, this is the right way to come to it, but we can see that if it's a wrong way, there might have been another way, but that is not the way that was followed, and it is not a course of reasoning that this court is obliged to follow here for any reason. And I remind the court again of the specific carve-out, to use a modern expression, that Lord Sumption indicated in respect of the very sort of arrangements that we are now considering, where he, in my submission, very presciently referred to the parties as regulating their own position by agreement. Finally, the position in relation to compulsory purchase order is not clear, and indeed is the subject of further proceedings between these parties. The provisos will not attach automatically to a grant of a right of discharge created by the compulsory purchase process. And United Utilities have been very assertive about this. The compulsory purchase powers are to be found in section 155 of the Water Industry Act 1991. That is not one of the sections which the provisos engage. And indeed, in the result, the Secretary of State, advised by an inspector, declined to impose what I might term homologues of the provisos in the grant made. And it is that refusal to do so which is the subject of a challenge to the confirmation of the order. Perhaps if I can end on a brief light note, the court may be reminded of the remarks of Lord Justice Wills in Bradford and the Eastbourne Corporation, which is a case about sewerage matters. The truth is that the whole of our sanitary legislation is in a state which I hardly like to characterise in the language that naturally suggests itself, and the attempt to extract from the various details of the legislation a set of harmonious principles, always underlying the specific provision, is, I am afraid, futile. He said that in 1896. I'm sorry to say it's still true today.
Or worse.
Indeed. Those are my submissions.
Well, Justice Arnold. Thank you very much indeed, Mr. Morgan.
May I just make a couple of points for your ladyship's note in correction. First, how the carve-out in Lord Sumption's judgment arose in relation to what was called the paragraph 50 point, which is the issue before the court. It arose because the parties, because of the judgment of Mr. Justice Nugee, as he then was, did not put the matter before the Supreme Court. It was specifically carved out.
Yes.
And
fully accept that.
And in relation to the school facilities management case, the paragraph to which Mr. Morgan referred, paragraph 154, is referring to cases not where the contract is a nullity, but where it is voidable. The paragraph...
That's the distinction Mr. Justice Foxton makes.
Exactly, and the paragraph which we rely on, we say is applicable, is paragraph 152, and we say that doesn't give rise to discretion. So those are the 2 points of correction.
Thank you. Well, thank you very much indeed for all your hard work, all of you. And I'm sure there's been a great deal of hard work further back in the rows here, for which we're very grateful. We're going to reserve our judgment. You'll be pleased to know, I think. And you'll all be fully aware of how these things work. When our judgment or judgments are ready, the drafts will be circulated. We would be grateful for assistance with typographical errors, not with re-argument, thank you. Then in the usual way, it will be, well, in what is now the usual way, they will be handed down electronically. And we'd be grateful if you can agree all consequential orders. And if you can't, your submissions should be short and in writing, and we will decide on the papers. And short means short. I should also say that as there have been some unfortunate events of late, that I'd be very grateful if you would all be hugely aware of the embargo that applies in relation to the draft when it goes out. Thank you very much indeed.
All right.